Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. We'll give a couple people a few minutes here to come join us, but it is Tuesday night, which means it is our normal Tuesday night live program. We usually go for about an hour or so. Sometimes we'll go a little longer if we have a very good discussion going on. Now, please, you can, if you have a question about any of the cases we're going to talk about, or basically anything in general, you can put it in the chat. Now, we don't ask or beg for super chats, but I will note that they get highlighted and their chances of that particular question being asked, the odds increase exponentially. Let's just keep it simple, all right? We'll keep it that simple. And there's a couple of things I want to talk about tonight. We're going to get to it, but the Kouri Richins case, what a mess that this case is turning out to be. Now, remember, one of the attorneys for Kouri Richins is also the attorney for Tyler Robinson, okay? And I don't want to disparage anybody too much, but the family may want to decide, hey, you know, his life is on the line, a lot of evidence against him. Like this, I mean, these attorneys have been preparing for the Kouri Richins case for what, 2 years now? And they just seem so disorganized in their case, which was somewhat evidenced by today, although the prosecutors had a little bit to blame for it today. So I definitely want to talk about that. And then, of course, you know, who wants to kill Rihanna? Well, apparently somebody does. And apparently what we know is that she is a speech therapist from Florida. The main question is why? Also like to briefly touch upon that case down in Georgia where the school teacher gets run over by the kids doing the school prank, and the mom or the husband, the wife of the husband that got killed, who's also a teacher, doesn't want any of the children prosecuted. Now, I said this when we talked about it the other day. Man, these kids are going to live with this forever. This is where prosecutorial discretion comes in, and they shouldn't prosecute these kids, at least not for a felony. The kid that was driving the truck. Apparently, the teacher was going out because he kind of wanted to join in on the prank. He thought it was funny. It was senior high school prank. And I get it. Who hasn't done a senior prank? We did. I remember we did. And we thought it was hilarious as hell. We found an old outhouse. We loaded it up in a guy's truck. There were probably 25 of us, and we dumped it right in the courtyard of the high school, and we put the dean of principal's name on it and the little sign that said that was his office. We were hilarious. It was hilarious. That's what the appropriate use for a you know, this is actually a wood building, an actual real structure, because there were still wooden outhouses out where we lived where people could, you know, had been used, but it was hilarious. It was a joke. Nobody got killed, but let's just say the, you know, principal, the dean of the students was not amused, and he was going to suspend everybody. You weren't going to walk in your graduation. So I also want to talk about that. And then, like I said, the Kouri Richins case, you know, we can totally get now, you know, for our Patreon members, you know, everybody signed up. We gave them their evidence guide. You know, it's the rules of evidence as it relates to everything. So, you know, you could sit there and literally watch, you know, the trial and be like, oh my gosh, they're implicating 702. What does that mean? You could quickly go to it and thumb to it. Or how about 801 D2 two statements? Those are non-hearsay, but what are the requirements for those? Well, we, you know, put it out here for you. A nice little table. It's good stuff. Anyway, I think we can still get you those. Maybe we can put them up in something on the link. Also got some new links in the bios, right? We're going to have a tip line. So if you got a big story, you got something, you can send it to us directly. The link will be down below. If you want to help research some cases, let us know. We'll do that. And we're working on a new merch store. So yeah, go check all of those out. We've got the Amazon store, the crimetalksearch.com link. an Amazon front, if I didn't mention that. And of course, the YouTube channels and all the social media platforms are linked there as well. So if you'd like to check that out, feel free to do so. All right. So let's get to it. First of all, for those who maybe have not joined us before, my name is Scott Reich. I am a practicing criminal defense attorney here in the great state of Colorado. And, well, what can I say? Going into my 31st year of practicing criminal defense law, we started this trial, I don't know, gosh, was it 7-8 years ago, right when the Chris Watts case started, because it was right up here up the road. People saying, hey, you should talk about the case. My first thought was no, but I was so frustrated by what was on the evening news. Nobody knew what the heck was going on. And everything that we talked about came through. When they said, oh, there's going to be a plea, they would have added on. I said, well, something's going to happen. Is it going to be a continuance or a plea? He pled guilty. So we've called it right on that. It's just like so many cases. Why? Because we know what's going on, not just some crazy theory. We actually give you what's really happening and what the legal maneuvering is going on. So like I said, a woman fired shots into the Beverly Hills home of Rihanna, and it turns out she's a licensed speech pathologist and apparently has made some cryptic social media posts about the singer. And general rule of thumb, if somebody says they're going to kill you, you should probably take them seriously. Now, I'm not sure Rihanna knew anything about this, but she may want to get a protection order against Ivana Ortiz. Hold on one second here. We got very, okay. I'm texting the Uber driver the text code. There it is. If someone wouldn't mind checking on that to pick up our food, that'd be fabulous. Anyway, I apologize. So Ivana Ortiz is being held in the Los Angeles County Jail with the shooting on the suspicious of attempted murder. I gave him the code on the text. Sorry. And her bail has been set at $10 million. Anyway, according to the Florida State Health Records, Ortiz has been a licensed speech pathologist since 2024. And her profile on Facebook appears to belong to Ortiz, featuring more than one post referencing Rihanna, including one back in February in which she told the singer, quote, say something to me directly instead of sneaking around like you're talking to me, end quote. It's not clear if Ortiz has any other personal connection to Rihanna. And the reality of it is, I'm going to go on a limb here. That I think Miss Ortiz may have some mental health issues, but hey, who am I to say? What can I say? When you start stalking people around their houses like that, making posts about them, yeah, you may want to kind of check your mental health. And if you don't think that you have those issues, all the more reason maybe to check them out. Okay, you do. All right, you're stalking people, going to their home, pulling out an assault rifle, an AR-15 style rifle, and firing that at Rihanna's home where her children are. You got some mental health issues. Let's just keep it simple. All right. That's just the way it is. So hopefully, obviously, Rihanna is going to be quite upset, she should be, because, her children were in the house as well. And she apparently doesn't know this woman. And then somebody literally trying to come and get you, kill you. I mean, that's a little scary. The next case we want to talk about here is the case down in Georgia, Gainesville, Georgia, where a high school prank turned a little deadly. So last Friday night, teenagers unspooled rolls of toilet paper outside the residence of a teacher named Jason Hughes. Well, apparently, Mr. Hughes slipped, fell into the street, and was struck by a pickup truck driven by one of the teens. Specifically, it was a teenager named Jaden Ryan Wallace, as they started to drive away in separate cars. This is all according to the sheriff down there. Anyway, after Hughes was struck, Wallace and the others, a kid by the name of Elijah Tate Owens, Aiden Hux, Anna Catherine Lukey and Adriana Cruz, all 18, stopped and tried to render aid until emergency responders showed up. But unfortunately, Mr. Hughes died. Wallace has been charged with first-degree vehicular homicide, which is obviously a felony. Not good, right? Young man looking at going to prison. He's also been charged with a reckless driving and a misdemeanor. The 4 other teens were charged with misdemeanor counts of criminal trespassing for obviously going onto the property to teepee the teacher's house, right? That's a problem. Not really. It's what kids do. We've all done it, okay? Anyway, the Hughes family says that the teacher, Mr. Hughes, knew and loved the 5 students and urged the police to drop all charges against them. And I agree. This is one of those cases where prosecutorial discretion should take over and do the smart thing, not just because the law requires it, but say, hey, these kids are going to have to live with this forever. They weren't doing it out of spite. The teacher apparently was, obviously the family's devastated, but the reality of it is there was no ill intent in this particular situation. Sometimes things can just be an accident. Now, of course, there's going to be some people say those teenagers were out gallivanting around being the little scoundrels that they are, right? And the reality of it is, that, some people are going to say you should charge the parents. Why were those kids out late at night? Shouldn't they be at home studying, thinking about their futures? But no, the youths of America out there causing trouble. See where it'll get you? It's a gateway crime. First thing you know, you're trespassing to teepee a teacher's house. Next thing you know, you're robbing banks. Where does it stop? The slippery slope never ends, does it, ladies and gentlemen? Anyway, I think that in this particular case, no charges should be filed whatsoever. All right. Now, if you think I'm wrong, put it in the chat. We'll respond to it. If you really disagree, just let it be known, and we will talk about it as well. Now, we talked about all the the new links. Oh, before we get to talking about the Kouri Richins case, that's right. It arrived. The battle box. Now, here's what we got to do. For those who don't know, this is not any sort of paid subscription. It's not anything that's promotion. Although if BattleBox would like me to receive this every month and do my little unboxing and send it to me for free, I would certainly appreciate it. But I understand. We'll do it ourselves. It's good entertainment. Anyway, so here's the problem. If you remember the Alec Baldwin trial, we were explaining the firearm, the single shot antique firearm. So I brought in my antique firearm that was actually issued to an officer at the Battle of Little Bighorn. It didn't quite go so well for the Americans, but the reference numbers say that would have been charged. I brought it in and I was like, why in the heck is our video being demonetized? And they said, well, you can't have any weapons on a live stream. And I was like, are you kidding me? It's an antique firearm that you couldn't even get bullets for. It was, 1880s. And anyway, so here's what I'm going to have to do. I'm going to have to open the battle box. I'm going to have to open the battle box without showing you the instrumentality that'll do it. Now, I can show you this. I'll leave it in the sheath, right? We've talked about this before. Fortunately, like I said, who else would have a K-bar when we were talking about, for example, the Brian Kohberger case? Well, this guy, because this guy's had this since, 1988, that summer after he went to boot camp, for goodness sakes. And unlike Brian Kohberger, I've never lost mine. Still have it. Actually, not the greatest thing ever. I mean, it's a great piece of gear, don't get me wrong, but keeping it sharp, not great. So anyway, I am going to unseal this without showing you the blade because we do not want Google to somehow think that I am going to commit some sort of self-harm on myself by showing the blade. That's how ridiculous the world has become, ladies and gentlemen. You can't do that. So that's why I'm going to do it out of your sight. Because although you may be adults and this is not made for children, there's somebody that will report it. I assure you of that. And it will create issues. And we don't want issues with YouTube. We like YouTube. We're trying to bring as many views to YouTube as we can. So anyway, here we go. Opening the battle box for the month of March. Now remember, this is the theme that they're doing. And I have not seen this. I do not know what it is, but we have our little battle box explanation. Once we get through this, we will then resume talking about the Kouri Richins case. So what do we see here? First, we have a mosquito bracelet, a plant-powered mosquito defense. All right, everybody hates mosquitoes, but this is reliable neoprene mosquito wristband, plant-powered mosquito defense. This is the Eden Defense Pack. It gives you layered, flexible protection against mosquitoes and flies in one complete system. Inside, you'll find a disposable mosquito repellent patches, bracelets, and reusable neoprene wristbands to refill pellets and disposable fly traps. Probably would never buy this myself, but look, it comes in the battle box. That's the whole point. You get stuff you probably would never buy for yourself. What have we got here? We've got, this is the stove. The Überleben Stoker stove is a minimalist dream fueled entirely by organic matter like twigs, pine cones, and moss. Eliminates the need for fuel canisters and keeps your pack light. It's a 5-panel flat pack design assemblies with quick and strong, stable stove. So apparently you take it out of this little pouch. Let's do this really quick. If I can do this, I may have to get it. Oh, it's got a sealed pouch of some type. You take it out. As you can see in that picture there, it looks like it's a stove. Apparently some assembly required, but it's German engineering. So you know it's got to be good, right? We like the Germans. So here's all the pieces. Apparently assemble it, and you can start it as a little area to start a fire, keep the wind out, and then add to a bigger fire. Who doesn't like that? Okay? Because, you know, when the big catastrophe hits of the world, there's going to be those that are prepared and, well, those that are not prepared. And that's why you need to go to Crime Talk Prep as well, crimetalkprep.com. Get yourself that, 3-month emergency food supply. And, it's good stuff there. Let's see. What else have we got? We have a 3-in-1 solar lantern flashlight power bank. So there that is. Some sort of, you plug it in, you can carry it around like a lantern, use it as a light. Who doesn't like all that stuff, right? Here, the assortment of burn relief supplies, right? Always need that, whether you're building your little fire with your little stove, or maybe you do something stupid like touch a hot pan or something. This is the Medic Burn Mod. Burns happen. Camp stoves, fire pits, hot cookware, friction. The Medic Burn Mod gives you the right tools to treat the burn-related injuries quickly and effectively. You've got gels, dressing. Put it in your old first aid kit. Can't go wrong with that. Always got to have emergency. What's going to happen? What's this? It's an adventure towel built for people who don't leave the water, trail, or campsite behind just because they got wet. All right. That's pretty slick. It's really light. Fits in a little thing here. It's got a little camouflage on the outside. I guess that's in case you don't want to get shot. You put out the big orange side so the hunters can see you, I guess. Right? Anyway, it's a towel. It's one of these little towels and keep you nice and dry. Can't go wrong with that, right? And it's super light. You could throw that in your bag, I guess, right? Let's see. What is this? We got some more blister mods. Ooh, super skin blister strips. Never know when you're going to get a new pair of shoes. Have to do that. Nature powered. Okay. I guess this is the box for all our mosquito repellent stuff. That's good. I'm not going to lie. It's a little light this month on the battle box. I'm a little, I wouldn't say disappointed, but I was expecting maybe just a little bit more. Some of the boxes are really packed, but oh, look, it also came with a big knife because we got the knife edition. So every month I get a new knife. We have so many knives around the house. I had to get a case. I received for Christmas a case for all my knives. Now this one, and it was funny. I was at the hangar where I keep a lot of this stuff because, you know, we're running out of space at the house there for all the knives. There was a guy that was there. He did some work on the plane on Crime Talk 1. And he was like, oh, look at these knives. I said, wait, come check out this. And it was a big knife like this. And he goes, oh, that's really cool. I said, you know what? It's yours. You can have the big knife. He appreciated the big knife. So, you know, just remember, when you get a new knife every month, feel free to give them away occasionally because you can. You don't really use them. In fact, there's some that I probably will never, ever use. But it's like Christmas every month when you get a battle box. Like I said, I don't get paid to open these by them. I use my own money. Some of the stuff is pretty cool. Some stuff, yeah, you know, yeah. But this one, a little light. I'm not gonna lie, it's a little light. Usually got something a little more intriguing in it, but still, it's good stuff. We'll sort it out. Maybe one of these days, what I should do is break out all the stuff at the hangar and just lay it all out and have like a garage sale. Everybody can come pick out their survival gear right there for them and take it home free of charge. You know what I mean? I guess we have to do that if you're local. All right, let's continue. Are there any good questions that have come up yet that I should answer before we resume talking about the Kouri Richins trial today? Apparently not. Let's do it. All right. The Kouri Richins case. Now, I don't know if people have been watching this. I hope you do. And I hope you watch it on our channel because we've been bringing it to you live every day. So what are the allegations if you're not familiar with it? This trial is going on in Summit County, which is in Park, Utah. And the prosecutors allege that back in March of 2022, Kouri Richins fatally poisoned her husband, Eric, by lacing a Moscow Mule cocktail with a lethal dose of fentanyl, approximately 5 times the amount that would be needed to actually make it fatal, which is, you know, I guess good initiative, poor effort. But then you have to realize that when you have 5 times the amount, it's really going to show up on those toxicology reports when the autopsy comes due, because, you know, this guy, Eric, was apparently relatively healthy guy. Oh, and they just happened to be going through some marital issues and maybe there was a lot of debt, etc. You know, the old classic stuff. And oh, by the way, Kouri Richins was also, you know, meeting up with the maintenance man. Yes, who had testified against her as well. So the prosecutors contend there was a financial gain through some life insurance proceeds. Like I said, some marital discord, mounting debts, alleged affair. I mean, how many times have we covered cases, ladies and gentlemen? You know, try to get rid of a spouse. There's always, you know, somebody else on the side going on. It happens, I guess. But the reality of it is, you know, you get a divorce, you don't kill people. That's what you do. And, you know, let's throw in the attempted poisoning from a previous time, and then a little insurance fraud and some forgery as well. So after Eric's death, Richins then authors a book promoting a children's book about coping with grief. So nothing says coping with grief like let's profit off this as well. And then, well, things tried to go, you know, a little bit south after that. She promotes her book. Things are going well. got a lot of public attention out of it. You know, she's still wheeling and dealing some real estate, and she ultimately is charged with, murdering her husband, like I said. And then we got the insurance fraud. She's got a bunch of counts. It's going to be a tough road to hoe to beat all of the counts, that's for sure. Anyway, Miss Richins has pled not guilty, and since a jury of her peers has not yet convicted her, she is entitled to the presumption of innocence. And today was day 11. Like I said, we were bringing you the trial from the beginning. The prosecution, however, is getting close to closing their case in chief. So what happened today? After some limited testimony, some cell phone records, the court recessed early following several hours of legal argument. The judge sent the jury home, and they're going to reconvene tomorrow at 1 p.m. The jury's going to continue deliberations. Or I'm sorry, hearing testimony. But they're going to start motions hearings at 8:30 a.m. What's the specific issue that caused the delay? It's a dispute over admissions and presentations of evidence, specifically selected portions of prior police interview transcripts and videos with Carmen Lauber, Lauber, the former housekeeper of the Richins and a key prosecution witness. Now, Lauber previously testified that she obtained and supplied the fentanyl pills to Richins at her request on multiple occasions around the time of Eric's death. The state now seeks to introduce limited experts from Lauber's earlier interviews through the testimony of the detective, likely the lead investigator, Detective Driscoll. Why? To rebut the defense's attack on her credibility and inconsistencies, or to show prior consistent statements. Now, the defense argues that out of fairness, that requires reviewing the full materials, which is about 1,000 pages and 7.5 hours of actual interviews. Now, for proper context, we got redactions and potential excerpts to present to the jury. The prosecutor pared it down to, I think, like 100 pages, what they think is relevant. Anyway, after extended debate, the judge granted the defense request for a 1-day continuance, and they had asked for 2 originally. And you should have seen the face. Well, I want 2 days. And the judge was like, oh, no, we're not doing that. We're getting close, and we are going to have this trial get to the jury. And they basically said, well, you guys have known about this issue. You were put on notice by the prosecutor a couple days ago. Why are we having this discussion now? The judge, I really like this judge. He seems very smart. He gets it, and he clearly understands the rules of evidence. And anyway, so then the defense attorney was basically like, well, if I can't have 2 days, can I at least have 1 day? Pretty please. So the judge says, fine, we'll do this. Go review those 7.5 hours and thousands of pages, and you tell me what you think needs to come in for the jury to see this. All right. So the evidence in dispute is regarding the admission of selection portions of these prior interviews. All right. To completely rebut the allegations of recent fabrication. All right. Or inconsistencies or improper influence directly implicating 2 provisions of the rules of evidence. All right. This is where the geek good stuff comes in here, ladies and gentlemen. So let me explain how this works, right? Witnesses can testify to what they saw, what they said, what they heard, but they can't testify to what somebody else said because that would be hearsay. Right? Hearsay is an out-of-court statement being offered for the truth of the matter asserted. Now, you always know when a prosecutor is not very smart, they're asking, well, judge is not being offered for the truth of the matter asserted, so I want this to come in. Please, judge. And the defense counsel says, objection, hearsay. Judge says, approach. Prosecutor says, judge, I really want this in. And it's yeah, sure, it's testifying to what somebody else said. And you say, well, how is that not hearsay? Is that person here to be subject to cross-examination? There's this little thing called Crawford v. Washington, the confrontation clause. And so the prosecutor could say, judge is not being offered for the truth of the matter asserted. Please let me have it. The judge looks at the defense attorney, Your Honor, this is clearly hearsay. Of course it's being offered for the truth of the matter asserted. If it wasn't being for the truth of the matter asserted, then I make a 401 objection that it's not relevant. And so the prosecutor, well, judge, I'm asking for the impact on the listener. What's the judge? No, that the prosecutor can say, did you have a conversation with the witness? Yes, I did. Without saying what that other person said, what did you do next? That's how you get around it. But most judges don't get that. They're like, oh, I don't know the rules of evidence just as badly as the prosecutor, so I'm going to let it in. Why? Because most judges are former prosecutors, and they're always they think they're entitled to get exactly what they want. Quick little story. We get, let's just say hypothetically, have a case. Let's just say hundreds of pounds of controlled substances are suppressed due to a brilliant legal argument that the firm came up with, based in fact and law. And the judge says, you need to do something, Miss Prosecutor. And she's like, we're not going to do it. We're going to appeal. Oh, okay. I look forward to taking this up, but I think the judge made a very good record. But let's go to the Supreme Court. So we look at the rules. All right, there's stuff there. What do? After, like 2 days after the deadline, they file a motion to reconsider. A motion to reconsider. Really? Why? Because she didn't get her way. Just dismiss the case and move on. They won't do that. Why? Because they're prosecutors. Now, don't get me wrong. I love most prosecutors. I probably have prosecutors on one hand, enough prosecutors on one hand that you can't trust, you can't talk to because they're dirty, rotten scoundrels and they're lying, cheating thieves. Okay? Probably in 31 years, I can count 5. Okay? I may have come across one recently. I'm just going to say that. But I won't get into that because, I'm not going to do that. But let's just say most prosecutors are out there trying to do their job. They're trying to do a good job. And then you got some people that, want to win more than they want to do justice. Remember, the ethics of a prosecutor is to seek justice, not win. Okay? And so most of them are good. Some of them you can't trust at all. Not many. Like I said, in 31 years, I can count on one hand the number of prosecutors that I can't trust. I had an interaction with one today. Great guy. He's moving to a different jurisdiction. He was very open, honest, candid, always been a straight shooter. Because remember, ladies and gentlemen, as a professional, your reputation precedes you. And nothing is worse than having your reputation sullied because somebody thinks that you cannot be trusted. And I swear to God, this is in my professional life and my personal life. When somebody says, right, if I say I'm going to do something, by God, I'm going to do something. And if I'm not, I better have a damn good reason why I didn't. Okay. And same thing in real life too. Prosecutors say, there's prosecutors. We all know people, you can do a handshake deal. You don't need to paper up everything. You should probably always paper up agreements, but that's the reality of it. And there's some prosecutors you can trust. You don't need, if their word is their bond. Nope. I said I would do that. I'm going to do that. Some detectives, I've had detectives show up and testify for my defendants in particular cases because they gave their word. That is important. But when they, I don't recall that conversation. No, I don't recall that. They can't be trusted. Okay. I'll just leave it at that. Most of them are good. So we're going to jump back here to Kouri Richins. Sorry, I got a little sidetracked. But really just, good. Most prosecutors are good. All right. So what are we doing? Kouri Richins' case, they have this housekeeper that allegedly buys drugs. She testifies. The defense, who I think did, I hate to throw stones because we've all been there in cases where, you're just like, man, I got nothing. The witnesses wouldn't talk to us. So really the first time you ever get to see them is on the witness stand. But for God's sakes, you know what you can get. And sometimes things change on this when the witness is on the stand, and you can always get a little more, but you won't know it until you get there. And these attorneys on the defense side, I literally want to go up, and I know their experience. They're like death penalty certified, because one is the attorney for Tyler Richardson, the kid in Utah accused of killing Charlie Kirk, right? Tyler Robinson. I misspoke. Tyler Robinson. So, they're qualified, right? They're death penalty qualified in the state of Idaho or in Utah. Okay. That means they've done like 5 homicide trials. Okay. Good to go. But I want to say, my God, you guys have been practicing law for a long time. You're the freaking defense. You give the witness the answer. It's called a leading question, right? Nothing shows you are more unprepared on the defense side when you give an open-ended, non-leading question to a defense witness. Well, what happened? Like, this is not a deposition in a civil case. This is in court in front of the jury. And my God, the jury can tell if you are being an idiot and you're incompetent and you don't know the facts of your case. And I'm really starting to feel like that's the way it is. I don't know if these attorneys are so overwhelmed or what, but please, for God's sakes, go refresh your recollection on what is a leading question. You tell them the answer. Witness, you did this, and then you did this, and then this happened, and it was this time, and you have the answer right there. And if they don't agree with you, you go up and you whack them on the nose, okay? Because you know the answer. And you go up there and you impeach their ass, and you say, I once had a dead baby case. And the witness, the dad who actually killed the child, I represented the mother who got a misdemeanor. It may have been on live TV or, ABC News. But the reality of it is, this guy was a piece of garbage, okay? He gave a statement, and I just went through his statement and said, you did this, and you killed little Alize, and you did this, and you're the one that did this. And I've just tore him up. And if he said no, at first, like, I don't know, I don't remember, I don't recall. I said, well, do you recall giving an interview to the detectives on whatever date? Yeah, I didn't. I don't know. I don't recall. All right, well, let's go back and take a look at this. You see, this is your name. All right, let me see. Here's the question asked by the detective. Here's the question asked by the prosecutor. Do you remember this question? And this is your answer. And that's different than what you said here today, isn't it, sir? You said it was all you then, but now today you're trying to blame him, right? So I go up and I whack him on the nose. Now, some people say it's like training a small puppy, but you don't whack a small puppy, right? You don't do that. You don't rub their little face in the poop. That'd be gross. You don't do that with a puppy. But you can with a witness. All right? And you just beat him up so bad. And by the end of it, this guy, all he knew, because every question I asked him, the answer was yes. And by the end of it, I could have said the sky was green, and he would have said yes, because he knew that I had the answer in the transcript somewhere. Okay? So defense attorneys, defense counsel, for God's sakes, spend some time, do a proper cross-examination. You tell them the answer. You tell them what you're going to tell them. Nothing worse than hearing a defense counsel ask, now it's appropriate sometimes in a motions hearing, tell me more. I'm not going to get to interview you. Please tell me more, child witness that I cannot interview without your parents there, but you're here in court. Tell me what happened. Oh, tell me about that. Oh, please, what happened next, right? Please. So think about that. So these attorneys for Kouri Richins have no freaking idea how to ask a leading question. I was sitting at my desk today trying to do other work, listening to the trial, watching the trial, and the last couple of days, and I'm just like, oh my God, please somebody tell them how to do this. So what do? The witness testifies, right? She's on direct examination by the prosecution. The defense gets asked her, basically the defense says, liar, liar, pants on fire. Well, you said this today and didn't say this, right? And the defense didn't do a very good job. I'm not going to lie. The defense did not do a very good job with that particular witness. So then the prosecutor's like, yeah, Judge, we're going to introduce some transcripts through the detective. And the defense gets all apoplectic. Well, Judge, this is a confrontation issue. We didn't get to do that. No, we didn't get to do that. And the judge is like, how is this a Crawford v. Washington issue, cross-examination? Because the witness has been subject to cross-examination. Just because you asked some very inartful questions and opened the door to rebut these allegations to prior consistent or inconsistent statements, right? It's not hearsay. So the only question then for the judge to make was, well, how much of it does it come in? The defense is like, well, if you're going to make us look bad and make it look like we, tried to cherry pick, and the judge was like, come on, everybody cherry picks out of the statement. Let's get for real. Okay. But you have to impeach the witness the proper way. Okay. Now I learned this the hard way once in a case. I think I actually won it, but it was pretty bumpy road. Back in the good old days when we had some good old fashioned gang violence here in Denver, it was freaking great. Okay. You got to do a bunch of trial work. You had, good guns and knives type of law, crime. You got a bunch of people that they ain't snitching. They ain't no snitch. That's like the old day stuff. Now everybody is such a little, excuse my French, they're all a bunch of little bitches. Everybody rolls. And I have always known this, but at least these people could at least try to hold out for a little bit. Now they just freaking just crumble. Cowards, I say. Because nobody wants to go to prison. Like, who wants to go to prison? I don't. But some people are like, man, that's like a rite of passage for some people in the, let's just say the lifestyle in which they grow up in. Some people go off to college. Some people go off to the military. Some people go work. Some people go to prison. It's like a rite of passage. That's just what they do in their particular communities. And anyway, so the witness gets up, and in good old gang cases, you never know what the hell anybody's going to say because it's a gang case. What happens? Gangbanger gets in trouble. Gangbanger wants to go home. Detectives come in and said, hey, this is no big deal. It's a little gun in the car, a little bit of weed. Nobody cares. But hey, while I got you here, why don't you tell me about this murder that took place over on 31st Street, or 33rd, the Trey Crips, something like that, right? And they're like, oh, man, I ain't saying nothing about nothing. But, you may want to talk to whoever's nickname he is. Throw a nickname out. Oh, really? How do you know that? Well, I don't know. Were you there? Oh, maybe I just heard it. Word on the street, word on the street. Back in the day, before text messages, you just had word on the street. It was freaking wonderful. Actually, I have real detectives do real work. All right. You had to go do real investigation, go poke around in real bad neighborhoods and talk to people that, it wasn't great. I always loved it. A couple of guys in a suit. You got your investigator packing heat. Let's go to these crappy neighborhoods. Let's go talk to these people and see what they word on the street is. Anyway, good old days. So the guys get up, they test, they say something to the cop. Somebody gets charged with a murder. All of a sudden, that guy that was thinking, man, I'm just trying to get out of this stupid weed case, maybe a dope case, gun case. And all of a sudden, now I'm in a freaking murder trial. Like, man, I ain't saying nothing. I don't remember nothing, right? Oh, you have no memory of it whatsoever? I don't remember saying nothing to nobody. Don't know how. No, I've got amnesia. And you think I'm exaggerating when I say this, like I'm being ridiculous. I've seen it all, right? So if they have no recollection of it, guess what? Their statement comes in. And back in the old days, they'd actually have them write it out. Most reliable thing in their own word, have them sign it at the bottom. Anyway, so the client, witness gets up there. I don't know nothing about nothing. Defense attorney gets up there. Maybe say it was me. Maybe he says something, yeah, my client did it. Oh, really? Today you're saying my client did that? Isn't that interesting, right? You had all this time. You're under your own prosecution. You're looking for a deal. And today you come to court and you make these allegations to get out and help yourself, you little ungrateful weasel snitch, that going back to the hood, you're going to have some rough times, right? And the guy goes, yeah, I don't remember if I said anything at all. I don't remember what I said. I don't even remember where am I? Okay. Literally, that's what they do. And then the DA gets up and says, Your Honor, I'd like to mark as prosecution exhibit 10. The witness's statement that he wrote. Objection, Your Honor. This is hearsay. Clearly an out-of-court statement offered for the truth of the matter asserted. The DA then goes to his book and says, no, Your Honor. 801D 1A, prior statement, not hearsay if it meets the following conditions. 1, the declarant testifies subject to cross-examination, got to be subject to cross-examination about a prior statement, and the statement is inconsistent with the declarant's testimony and given under the penalty of perjury at trial, hearing or other proceedings or in a deposition, or B, consistent with the defendant's testimony and is offered to rebut an express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in testifying, or to rehabilitate the declarant's credibility as a witness when asked on other grounds, or C, identifies a person as someone the declarant perceived earlier. So remember that, ladies and gentlemen, prior consistent, inconsistent statements, anything to rebut the allegation of recent fabrication in court. Oh, really? You come to court today and say this for the first time? Isn't that convenient? You had all these opportunities to say this before and you didn't. Prosecutor says, Exhibit 10, please. Prior consistent statement. Right? Because the defense attorney didn't want to talk about that statement because, my God, he knew that's what he was going to say, right? So you kind of say, oh, you just happen to say this. Now, some DAs don't know this because most DAs don't know the rules of evidence very well. Okay? So that's exactly what the prosecution is going to do. Okay? And if the defense wanted to show inconsistent statements, obviously they can impeach the witness. And they can say, Miss Housekeeper, isn't it true you said B today here in court? Yeah, I think so. Yeah, I think that's what I said. Well, isn't it also true you gave a statement to the police officers back on this date? I don't recall. I'd have to see the statement. Okay, well, let me pull out a transcript. Take a look at this. Do you ever see that transcript? Did you say that on that particular day? Does that refresh your recollection? Yes, it does. Yes, it is. It looks like I said that. Right? Now, if she denies that, then the defense gets to bring in the police officer to say, on this date, did you interview the witness? And did they say A, whereas they said B here in the courtroom here today? Yes, they did. Okay. It's an impeachment witness. But the prosecution has the better hand in this particular case. And now what the defense is saying is, well, Judge, if you're going to allow in these statements to make it look like I was trying to get something over on the jury implying recent fabrication, I want the entire 1,000-page, 7.5 hours to come in. And the judge is like, well, no, we're not going to do that. They're saying, well, under Rule 106, the rule of completeness requires that. That's the rule that states that when a party introduces all or part of a writing or a recorded statement, an adverse party may require the introduction at that time or any part of the statement. That is in fairness to be considered at the same time. It functions as a non-discretionary safeguard against misleading or out of context presentations, right? So you're about, oh, Judge, you took that out of context. You cherry picked it. That's right. Let's take a look at the whole thing, right? Everybody cherry picks. That's what we do. All right. But under the rule of completeness, you can actually say, no. We want it all to come in. So the defense here was arguing that the prosecution's selective excerpts risk omitting exculpatory or giving context to the statements that were made to the police where the police were kind of putting some pressure on her and obviously trying to make a deal. They therefore requested time in the Richins trial to review the full materials and designate additional portions or redactions. The judge applied the Rule 106 on a chunk at a time basis, determining whether proposed additions were necessary to qualify, explain, or to place into context. Anyway, the judge granted this one-day continuance, denying a 2-day continuance was requested by the defense. Then the court's going to have to do a balancing test under Rule 403, right? 401 is it relevant? And this is what most people don't get, okay? And this is why I hate to say it. Sometimes you got to go to law school. All right. What is relevant? Under Rule 401, the legal definition says evidence is relevant if it tends to make a fact of consequence more probable or less probable. Well, what is a fact of consequence? A fact of consequence is the elements of the offense charged, right? Kouri Richins charged with murder of her husband, Eric. So what is relevant? On this date, on or about this location, the defendant, not somebody looked like the defendant, not somebody using her identity, but in fact, the defendant took the life unlawfully of her husband, Eric Richins, after deliberation without, legal defense. If it doesn't go to one of those elements or one of the other charges in that element, it's not relevant. And that's where most people get screwed up when it comes to trials. If it doesn't go to prove or disprove an element of the offense charged, not relevant. But everyone thinks they're going to relitigate, particularly like in domestic cases, right? Even in a homicide, we just did a murder for hire trial. Murder for hire case. It resulted short of trial. And, so once again, crime talk. That's right. Me personally have experience with, little murder for hire cases, murdering your spouse, allegedly. Okay. Everybody in those type of cases thinks that we want to relitigate their entire relationship. Not relevant. Don't care. Okay. Think about it. Your life is like, remember those old movie reels, the little 8mm movie reels, if you're older. Remember your parents had those and they put them on and they did it. Well, think about that's your life. Okay. And if you took those little reels and you spread it out, that's your life from the beginning to where we are now at the end down here. Well, guess what? If that's your life, you're going to take your little splicers of that film and you're going to cut out this little spot. One day, possibly, could be seconds, maybe a few minutes in a day, is only really relevant as to what took place as it relates to the crime charged. Okay. The fact that you were a Boy Scout and maybe an Eagle Scout, don't care. Not relevant. Not a defense. Oh, he's a good guy. Well, I don't know. Good guys. Good. How's that relevant if he's a good guy? Good guys can kill people too. That's what most people forget about. They want to completely relitigate stuff. So the judge, I think, gets it. The defense made some silly arguments today, and I say that not bringing any pleasure to me. I like when the defense does a good job, but they were making some silly arguments about, well, Judge, this violates the Confrontation Clause, Crawford v. Washington. The judge is like, tell me how. Do you have any authority on that? Because the witness testified under oath, was subject to cross-examination by the defense. Okay. And besides, this is not hearsay coming in because you basically opened the door by trying to say that there was recent fabrication. So those prior consistent statements are not hearsay. So it was a tough day for the defense. It's been a tough day just about every day for the defense. I've been watching it and I just And I hate to do this. I do. Because people are like, oh, Scott, you think you could do better? Yes. Yes, I could. Okay. Yes, I could. And at least, I mean, they look defeated. Kouri Richins' attorneys, they look defeated. They look like they've been beaten up. They're beaten down. They know the evidence is coming in. It's starting to pile on. The prosecution's just about done with their case. The defense has to decide, what are they going to do? What are they going to put on? Okay. And that request for continuance today, I've never seen anything more pathetic. First of all, apparently in Utah, you get to sit on your ass when you're talking to a judge. I don't like that. I think it's ridiculous. I don't know why judges somehow think that they should ever allow that. It is disrespectful, not only to the court, but to the proceedings in and of itself. You get your ass out of the chair, you stand up, and you say, and you state your case. You make your objections. It's just not as persuasive when you're sitting your butt in the chair and saying, well, Judge, please, really, I'd like to do that. So, no, stand up there with like got some authority and argue your case. Even if you're freaking wrong, act like you own the place. Unbelievable. It was, I hate to say it. I actually felt a little sorry for Kouri Richins. I did. And she seems like a pretty unlikable person. She really does. And I was feeling a little bad for her. She kind of that look in her eye like, please help me. My attorneys suck. That's the look I saw. Okay. It's going to be interesting to see if she testifies and takes the stand. It'll probably happen, I would venture to guess, by Thursday. So if you haven't been watching the case, you need to come check it out. We have it here on Crime Talk. We've been bringing you gavel to gavel coverage. It starts at 8:30 tomorrow morning. The motions hearing. We'll see. The prosecutor is going to try to pare it down as much as he could. The judge is worried about appellate issues as well. So he doesn't want to, dump in everything. But the portions that the prosecution is going to designate, the defense is going to have to object, state that it's not a prior consistent or inconsistent statement. Now, here's the other thing. This could have been done quite easily on redirect. The prosecutor just simply had to say, Miss Housekeeper, who's been accused of fabricating your story to get a better deal for yourself and not tell the truth. First of all, are you telling the truth? Yeah. Is it because you're getting a deal in this case? No. Do you recall having a conversation with detectives? Yeah, 7.5 hours, right? And the first statement that you made, was it the truth? No. Remember that, ladies and gentlemen, the first version is never the truth. Think about it. Use your common sense. Your kids get in trouble. They're arguing. They took a cookie from the cookie jar. I don't care. And they get caught. And they can have cookie crumbs all over their lips. And you ask them, who took the cookie from the cookie jar? And they say, we don't know. I don't know. And they say, well, that's funny because I got some circumstantial evidence that there are cookie crumbs around your mouth and they fell in your shirt. And they look at him like, oh no, really? And then they say, you sure you didn't take a cookie from the cookie jar? They use a little Reed interrogation technique. Well, maybe I just had one, right? The first story is never the first one, particularly in criminal cases. Take the first story with a huge grain of salt because usually it's a freaking lie. Then they get serious once the prosecutors or the detectives show to the witness that their story makes no sense. We've already thought about that. We've got everything to back it up. And they're calling you a liar. And now you're going to go to prison for the rest. Like, fine, I'll come clean. Let me tell you how it really happened. Sat through too many proffers. Okay. Doing that, even when you're not going to get in trouble, like just tell the truth, man. They think they want to lie. They want to protect somebody. So just saying, ladies and gentlemen, take it with a grain of salt. We'll have to see if Kouri Richins does it, but I almost felt sorry, just a little bit, be sorry for her today. And don't get me wrong, I always I like rooting for the defense. Okay. Anybody can be a prosecutor. You get up and say, and what happened next? And what date was that? Seriously. Defense attorney, you got to be able to take a hot pile of steamy, what, and turn it into something. You know what they say? How you going to polish that turd up and do it? Yeah. That's what defense attorneys do. Anybody can be a prosecutor. What happened next? Detective, it appears that you're have a badge on your belt today. Or officer, it appears that you're in a uniform. What do you do for a living? What is your training experience? Let me draw your attention to a particular date. On March 10th, did you receive a call for service? I did. And what did you do? Well, I arrived at the place. I exited my patrol car, because they don't get out of their car. They exit their patrol vehicle. And I went and talked to somebody. And what happened next? That's all. Prosecutor gets delayed, doesn't know what the next question is. You just say, and what happened next? That's it. You just kind of go chronologically. Defense attorney, sometimes you got to work with when you got nothing. Okay? I'm telling you, the best attorneys in the world are criminal defense attorneys. Remember Mr. Codwell? We have him on the show. He agreed with me. Anybody can be a lawyer, go to law school, pass the bar. Okay? Anybody can be a litigator, be in a paper pusher, do this, move that, file objections, ask interrogatories. But to be a real trial attorney, you have to actually go to court and try cases. And the best ones, they're defense attorneys, because they got to deal with the worst facts. They have to deal oftentimes with the complete despised and the damned, the most unlikable human being ever on the face of the earth. And hell, they may not even like their client. They may despise the client as much as the jury and the prosecutor may. And you got to make it look like you like them and defend them zealously as they're required under the Constitution. Okay? So keep that in mind. So Ms. Richins attorneys, I hope you put on your A game here. I don't know what it is. Idaho, Utah. I know there are great attorneys out there. I just feel like, even if you're getting your ass kicked, you got to do it, right? I had this case years ago. I started out, just one little story. It was a horrible story, but you're going to want to hear this, okay? And you're going to want to hear it because, well, sometimes when people just think they're smarter than everybody else, they're not, okay? So I get this case. Not exactly sure how it comes to me ultimately, but this guy was a former priest and apparently coming to some money and decided to not be a priest, but he wanted to be a foster parent. Only requirement was he would only be a foster parent to young Hispanic boys between the ages of 8 and 14. Well, let's just say when he was a foster parent, some of the kids wanted to get out there as quickly as possible. But this particular client, remember the former priest, foster parent, everybody thought he was the greatest guy ever. Oh my God, you're taking all the kids we can. Oh, it was great. Yeah, it's because he's doing terrible things to him in the hot tub. Okay. And in their bedrooms. Make a long story short, years go by. He gets arrested for doing terrible things to young boys that were in his foster care. He takes a plea deal because the feds are going to indict him because he's had some, child exploitative materials found in his house. And this is 20 years ago, maybe less. So it wasn't like on a computer or phone. They were just old, creepy man photos that he had, acquired. It's just gross and weird, right? Well, he pleads guilty, doesn't like it. Spends a bunch of money through another firm, and they withdraw his guilty plea. Says he was coerced, didn't understand it. Previous attorney was terrible. Should have gone to trial, all the routine. Buyer's remorse afterwards. I get him. I think I was court appointed on this case. And I remember a friend of mine, that's what it is, a friend of mine just got appointed to a death penalty case. He says, "Hey, Scott, I got this horrible case. Would you take it for me?" I'm like, "Okay, man, you're going to be a death penalty case. Sure. What is it?" Didn't even know what it was. I'm not even going to mention the guy's name, but I still remember it was terrible. Anyway, so we go to trial, and I'm like, I got this. I got this. Our defense is liar, liar, pants on fire, prove it beyond a reasonable doubt. Not a bad defense if I say so myself. And we go to trial, and, my guy he looks weird and creepy. Just terrible. And he's probably still alive because he's such an evil person, because he was like 75 years old when we tried this case. He's probably still alive because evil people don't die, right? Anyway, it becomes quite evident that like the 20 victims that they parade in front of the jury all had very similar stories. And coincidentally, none of these children had ever met. They're grown adults right now, right? And, seeing grown men cry on the witness stand because they were sexually assaulted, that's tough for everybody to see. It really is. The guy's like, yeah, I just kind of blocked it out. My wife, I had to tell my wife about it. Oh, it's affected our marriage. Ugh. And my client's just like, I'm sitting there the whole time. He's just whispering, liar, liar. Of course, I get up there. Oh, liar, liar, pants on fire. Oh, you didn't tell anybody back then, did you? You didn't tell anybody in your 1, 2, 3, 4, 5, 6. Just going through, beating them up. Boom, 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 boom. And the jury's just looking at my client like, you scumbag. Right? So we continue to go to trial. Ultimately, jury comes back, promptly finds him guilty. Now, we don't need to wait for sentencing because, he'd already pled guilty. There was already a pre-sentence investigation report. So the judge says, we'll do sentencing tomorrow. Half the jury showed up. Half the jury showed up because they wanted to see my client in shackles. And not saying he didn't deserve it. Okay. And one of the jurors came up to me afterwards and he said, probably like they're talking about in the Kouri Richins case. Yeah, we really expected a lot. It was really, you're so confident, sitting up straight in that chair. You were ready to go. And as the trial progressed, we could tell that the beating was getting harder and harder. I'm like, oh, really? How could you tell? Because I want to make sure I don't do this again. Was I making faces? No, you were stone cold poker face the whole time. Didn't let anything bother you. I said, what was it? They go, you started to slouch over. You didn't sit up as straight as you used to. You were just like, oh my God, make it stop. Make the beating stop. So I always try to sit up straight in trial, even if I'm getting my ass kicked. Okay. Just a little thing though. Jurors notice that. They notice everything. Okay. They notice everything. And that's why you always got to tell your client to sit down, shut up, and just smile. Nothing's bothering us. So that's how I feel for Kouri Richins. It feels like she's taking a beating. I get it. Like I said, I always root for the underdog. I root for the defense because they are the underdog. And it just seems like it's starting to pile on here just a little bit for her. Tiger Torch. Lawyers can get PTSD too. I totally agree. Either I, keep my heart in a jar of formaldehyde next to my nightstand, or I probably have PTSD of everything that I have seen over the years. But that's okay, because you just move on, you march on. That's it. But yeah, lawyers do get it. And actually, there's a pretty, I wouldn't say a high percentage, but I would say, at least in our little community here, and probably lose one attorney once every year, every 2 years, because they commit suicide, because they just take it so personal. And you can't, and you got to just move on. You can't do it. The reality of it is that The attorney did not create the facts. We're just working with what was created. And I remember as a young attorney, oh my God, I was a young defense attorney. I'm representing this, water walker Marine, and he's going to lose his retirement, and they're going to kick him out of the military, and it's all on my shoulders. I've got to do this. If I lose, it's going to be all on me. And then you lose a couple of those, and you sleepless night, and you become a terrible father and husband, and because you're always thinking about, whatever's going on, and you're not giving your focus where it should be. And eventually you try to realize that, you got to turn it off. You have to be able to say, I didn't create the facts. And yeah, the guy may be a water walker Marine. He had a great career, and he blew it all for what? It's no different than somebody, going out and getting a DUI, and they need their license for a living. Not my fault, man. I'll do what I can, but don't blame me. You're the one that created the facts that have brought us all here together. Remember that. All right. Yes, Jody, it can be a tough job. It can be a tough job. Yes, totally agree. I would like to say that the chat during the trial is one of the friendliest chats. So welcoming, difference of opinions, but everyone doesn't argue. Well, Debbie Vigil 2322, that's what we like about it. People, you can agree to disagree, but you can do it politely, right? Kind of like in a courtroom. One side says their point, counterpoint. You can't call other people's names in court. You can't call them, derogatory things. That's the way we kind of like to keep our chats here. Yeah. Oh yeah. The PI yesterday was snarky, but came across as truthful. I'd hire him if I could afford him and needed to. For those who don't know, he was the PI that was hired by the estate to basically get all the emails address or all the text messages and things like that. And it was just interesting. And he held up pretty good on cross-examination. And he's been a defense attorney or defense investigator for 20 years, done a bunch of cases. He's like, yeah, the first time I've ever testified for the prosecution ever. But he's telling the truth. And of course, he just had like back fusion surgery. So at one point he has to put on his neck brace to do it. So anyway, it's going to get interesting tomorrow morning. I'm going to try to watch it. I have to go with an investigator on a little jaunt in the morning, but we will be watching in the car the motions hearing. We'll see what comes in. My guess is just about everything will come in. And the defense screwed the pooch on it, man. They didn't do it the right way. You got to be careful. And I understand sometimes it's a Hail Mary, but man, if you start opening doors and things like that by, oh, you lied and you did this. You got to be worried about those consistent statements, right? Just like if my client is going to trial and he makes a statement to the police that says, I didn't do it, or it was self-defense. Guess what? The prosecution is not going to introduce that statement. So the only way I can get it in is my client. But then they say, oh, really? You just testified to this today. You're charged with that. Oh, really? Guess what? We're going to call the detective to the stand, and we're going to ask him what questions he asked my client. And what were those answers as a prior consistent statement? And I would also ask my client, do you recall being interviewed to them? What did you tell them way back then, since they tried to imply that you just got on the stand to save yourself today? Prior consistent statement. Yes, yes, yes. You got to be careful. You got to know what you're doing. Rules of evidence. You got to know the rules of evidence. So, if you like to get your federal rules of evidence, basically the federal rules mirror just about every state, a few nuances here and there. I think we can figure out a way to get those to people for nominal or no cost at all. So we'll see what we can do. All right, everybody. Thanks for watching. We'll see you next time. Thanks for joining us on Tuesday Night Live. We'll have a show for you tomorrow afternoon as well. And remember, the Constitution matters.
All right, lawyer.